Thank you very much, and good afternoon, good evening, and good morning to honourable judges and justices and environmental lawyers, environmental law champions joining us from 66 countries from around the globe. Welcome to the final session of our three-day second ASEAN Environmental Law Conference. My name is Matthew Baird. I'm the Director of the Asian Research Institute for Environmental Law. And on behalf of ARIEL and our great sponsors, the Asian Development Bank, the College of Law, and the United Nations Environment Programme, USAID Wildlife, and the Global Judicial Institute for the Environment, I'd like to welcome you and thank you very much for being with us over the last 3 days. Today, we finish our discussion on environmental law with a bit of a focus on some of the really important and key players in environmental law, namely environmental judges, and looking in particular about how environmental courts and tribunals can assist in the achievement of environmental justice. And we're joined today by 4 distinguished jurists, all of whom have exceptional credentials to talk about both environmental law and the rule of environmental law. And I'd like to introduce them, and then we will head to the initial discussion questions. And can I encourage all participants to please use the question and answer box or the chat box to raise the questions for judges about the environmental rule of law and how courts in particular can play their part in protecting and preserving the environment in accordance with principles of environmental law. It's also important to note that this year is the 50th anniversary of the Stockholm Conference and the Stockholm Declaration. And indeed, there are a number of international environmental law instruments that celebrate their 50th birthdays, including CITES, UNCLOS, the United Nations Convention on the Law of the Sea, the World Heritage Convention, and there are this idea that environmental law jurisprudence is now emerging and crossing all different jurisdictions. Our 4 speakers today include former Associate Justice Adolfo Azcuna, who was a former Justice of the Supreme Court of the Philippines. His biography is extensive and indeed identifies him as being one of the truly great environmental law jurisprudents within the Asia region. His involvement with the Supreme Court of the Philippines was then followed as the director of the Judicial Training Institute of the Philippines. He was also involved in the drafting of the Philippine Constitution and has served on the bench and after the bench in his active retirement to keep many people and many students engaged with environmental law. From Thailand, we have Justice Angkana Sinkaseam, who earned her Bachelor of Law degree from Thammasat University and her Master's from the University College in London. She entered the Thai judiciary in 2006, and she has served as a research judge in the Environmental Case Division of the Thai Supreme Court for many years. And Judge Angkana is the Secretary of the Environmental Case Division of the Thai Supreme Court. From Australia, we are also joined by Justice Rachel Pepper, who was appointed a judge of the Land and Environment Court of New South Wales in May 2009. She is also an adjunct professor at the University of Sydney's Law School and a fellow of the Australian Academy of Law. She's a member of the Ngara Yura Committee of the Judicial Commission of New South Wales and a member of the AIJA Indigenous Justice Committee. Justice Pepper was also the associate to Justice Michael McHugh of the Australian High Court prior to being called to the bar. She's the author of many publications and articles and has been a participant at a number of workshops and events organised by the Asian Development Bank in Southeast Asia. And from Indonesia, Judge Bambang Mulyono, the head of Judicial Training Centre from 2019 and Chief Judge at several district courts prior to his appointment as head of the Judicial Training Centre. He's a member of the National Environmental Law Working Group, a member of the World Commission on Environmental Law, and a member of the Working Group on Judicial Education and Training. And he'll be talking to us in particular on the judicial environmental certification process in the Indonesian courts. So first of all, this roundtable, I'm going to ask a question to each of our judges. Again, I would also ask the participants if they wish to pose questions in the Q&A box. And so the first question is to Justice Pepper. So the Land and Environment Court of New South Wales was established in 1980 by the New South Wales Land and Environment Court Act at the same time as the New South Wales Environmental Planning and Assessment Act came into force. Since then, it has developed significant environmental law jurisprudence and has been seen as a role model for environmental courts. In your opinion, what are the key factors that have made the New South Wales Land and Environment Court a model for other specialist environmental courts in the region and the world?
Thank you very much, Matthew, and thank you for inviting me to the conference. I wish to just commence by acknowledging the traditional owners of the land where I am located today, namely the Gadigal people of the Eora Nation, and I pay my respects to their elders past and present. To answer your question, which I've thought about a lot, I think there are probably a couple of factors. One is, and probably the most important, is we're a superior court. So we're not a lower court. It's not, and please, I'm not in any way trying to denigrate courts of lesser jurisdiction, but I think because we're a superior court, it means that the court has significantly greater powers than other courts, which I think then has flows on to the types of matters we hear, the types of remedies that we have available to us, the types of orders that we can make. And that also, I think, has had an effect on the breadth of the jurisdiction that we have as well. So our court, and I guess that's the second element of why I think our court is a model court, is because we have a superior court, which is obviously has a degree of gravitas associated with that as well. The types of cases that come before us are serious cases. But we also have this broad, exclusive jurisdiction. So the matters that we deal with, only we deal with, which is very important. And that's allowed us to develop a degree of expertise and develop a jurisprudence as well, which is very important. And that broad jurisdiction that we do have covers everything effectively that you can think of to deal with the land, air, sea, and includes both civil and, importantly, criminal as well jurisdictions. So as I said, that collection of superior court powers and a broad specialist exclusive jurisdiction covering both civil and criminal law has allowed us to develop particular skills and expertise, and also an expansive jurisprudence as well. I think you're on mute, Matthew.
Sorry, not the first time and probably not the last time. I will mute myself. So actually, Justice Pepper, can I just also ask, I mean, the Land and Environment Court also has a sort of a commissioner jurisdiction which also deals with technical matters. Is that something that is also sort of relevant, that there is this separate aspect of the court where particular planning matters and other technical matters can be heard by assessors or commissioners that are also, I guess, connected with or receive the benefits of the whole experience of being part of, although separate in some respects, to the Land and Environment Court or the judicial officers of the Land and Environment Court?
Yes, no, I would totally agree with that. So we are, again, unique insofar as we deal with, we have judicial officers in the court who exercise judicial power, but we then also have commissioners who deal with, and they deal with the administrative matters. But because it all sits under the one court umbrella, we end up being a sort of a one-stop shop, if you will, for developers, for environmental cases. As I said, you can bring anything in that sense to do with the jurisdiction of the court within the one court, which I think is very, very useful. And because the commissioners sit under the court, we have the benefit of the commissioner's expertise, which is very important. Our commissioners aren't all, in fact, very few of our commissioners are legally trained. We have people who are specialist arborists, we have engineers, we have planners, we have architects. So we get the benefit of their knowledge. And by the same token, they get the benefit of our knowledge as well. So there's that sharing of information, sharing of methodology as well. And the judges will sometimes sit with commissioners, which greatly enhances our capabilities.
Thank you very much, Justice Pepper. So Justice Azcuna, if I could turn to you now, and environmental law jurisprudence in the Philippines is quite well developed, with a number of very important judgments handed down by the Supreme Court of the Philippines. The Philippines does have some constitutional provisions, and it also has other interesting things such as the writ of amparo and the Supreme Court rules of procedure in environmental matters, all of which you've been very intimately connected with. In your opinion, which of those elements has promoted environmental law jurisprudence in the Philippines, or is it a combination of all of those elements?
Thank you very much, Matthew, and thank you for inviting me to this forum. I believe that all these elements contributed to the development of environmental jurisprudence in the Philippines. But foremost of all this, really the provision in the Constitution, which I think started the whole thing with the decision of the Supreme Court implementing it in the famous Pactoran versus Oposa case, which became internationally renowned. And later on, the Supreme Court further strengthened the enforcement environment by adopting specific rules for environmental cases. And embedded in those rules is the writ of kalikasan, which is Filipino for environment, especially fashion writ to protect the environment. So this all taken all together, including the role of the Philippine Judicial Academy, which is our counterpart to the Academy of Judge Bambang in Indonesia. We train judges to handle environmental cases. And very often, like what they do in New Zealand, we train the judges together with the forest rangers so that they can coordinate their actions. So all this, Matthew, I think contribute to the development of environmental jurisprudence in my country.
Thank you. Thank you, Justice Azcuna. Can I just also, focus on that issue of the constitutional provisions? And I come from the point of view of an Australian, where we've had our federal constitution since 1901, 1900. It hasn't changed much. And in 1988, a constitutional commission considered a range of issues as to whether or not we should have an environment right, or environment should be a matter that the Commonwealth should have control over. In terms of the Philippines constitution, that provision providing the Filipino people with that right of appeal, can I just ask, how did that come about? I know that there's a good story about it, and it seems that it was also that time, or that area where having that constitutional provision then allowed a lot of other things to be built, including the rules of procedure. But even some of those important cases, such as Oposa and Factorum, were actually decided before the rules of procedure, including, I guess, the resident marine mammals of the Tanyon Strait, which actually also was before the Supreme Court rules of procedure in environmental matters had been enacted. So I wonder if you could sort of share with us a little story about that particular provision in the Philippines Constitution.
Yes, Matthew, it started by way of the development of the Declaration of Principles as a part of the new constitution that we were framing after the People's Power Revolution. And the sentiment then was to expand democratic space. And one of ways expanding this is in the environment. So one of the commissioners, Ed Garcia, proposed in the committee of the Declaration of Principles a provision which states that the state shall recognize and respect the right of nature to follow its own rhythm and harmony. That's a beautiful expression, but it was opposed by the only lawyer in that committee, who said that it cannot be passed that way because nature is not a person and therefore cannot have a right. And of course, now that is a new doctrine that nature has a right. But at that time, 1987, it was unthinkable to grant the right to non-persons. And so they were stymied, and the president of the committee of the Constitutional Commission sent me to find out what was happening. And when I found out what was happening, I proposed a compromise and to give this right not to nature, but to the people. And it passed that way. But the rhythm and harmony is still there. So I'm very happy that that phraseology was preserved upon the insistence of Commissioner Ople. So we have the right of the people to a clean and healthful environment in accord with the rhythm and harmony of nature. That's how it developed. So that is part of our Declaration of Principles, and I insisted in the phrasing of that as a right, so that it is enforceable, and it is the duty of the state to protect that right. And that is the framework in which the environmental protection and enforcement is happening in my country. And I coupled it with a provision in the articles on the judiciary by giving the Supreme Court the power for the first time to adopt rules to protect fundamental rights, or what is really a writ of amparo. And combined with that, the Supreme Court could then implement the right to a clean environment by special rules to protect the environment. So this is what happened. These two provisions in the Constitution, a substantive right to a clean environment and a procedural right to its enforcement, which cannot be undone by legislation because it's in the Constitution. So this is what we did.
Thank you very much, Justice Azcuna. And I certainly want to get back to the in our next round on the rules of procedure. But it's also, I think, important to acknowledge that in 1987, this was 35 years ago, it was 5 years before the Rio Declaration. I mean, it shows that there was that bringing that into the Constitution can certainly transform the way we look at law and the enforcement of rights. You also mentioned the issue of training. To that, I'd like to refer to Judge Bambang. You've been involved in the training of judges in Indonesia for many years, both in your capacity now, but also, I think, maybe 30 years ago or 20 years ago with Professor Ben Bohr and Professor Rob Fowler. And so in terms of, and certainly Indonesia in terms of its certification for environmental judges, was also one of the early leaders in this. I'm wondering if you could share us some observations about the training and certification of environmental judges in Indonesia. And I understand you might have a short PowerPoint. Whenever you want that we can play that. I think Gladys is ready for that. So.
Okay, thank you, Matthew. I think I don't need because the PowerPoint is a long time to explain. But I think next, please. Next, please. Oh, okay. Yes. For the training of the certified judges, so every year we conducting of training for judges, and this training is national priority. One of the training where every year we must make a training about certification environmental judges. According to the evaluation of the training, we in the Judicial Training Center continuing to improving of method and also improving of alumni of the training, where every alumni we improving their knowledge with a workshop or FGD, or we discuss about the special case where related to the updating issue. The Judicial Training Center is not work only, but also support by National Environmental Working Group in the Supreme Court, where the members of the working group are justices and judges, and also civil society, for example, from the Indonesian Center for Environmental Law, ASEAN. And we continuing the discussion where we find the problem of enforcement of the environmental case. And Yes, we since 2012 conducting of a training. We make certified judges, and until now, the alumni of the training are 1,262 judges. But we not only the numbers, the real numbers, but because Indonesia was very rich area, about 350 courts in the first instance. So we the improving of method and also the material, we every year circling to improving the material. And please next. Yes, this is beside the training, we also in the research of in the Supreme Court also we make a choose of the legislation where we can use as a material for the case study. This is, for example, a case about Joko Prianto and the government of Central Java, and friend of the earth Walhi versus PT Indrayon. This where Walhi as a NGO accepted as environmental organization standing to bring the cases to the court. And some landmark decision is different cases and different as a standing for the parties, and also applying of principle environmental principle. Next, please. Now the effort of the Supreme Court and the working group, and we revise of rules of procedure for environmental cases, where we use since the 2030, and since last year we revised these rules, and perhaps in this year where new rules with more complete of the procedures. And then why this we improving of the rules of procedure for environmental cases, because we need procedure arrangement for anti-SLAPP case handling, because many cases was not properly a good decision by the court. So this procedure we also learn from the Philippines, from PILJA, about anti-SLAPP, and other countries were applying anti-SLAPP. And more extensive arrangement regarding the flow and procedure for environmental restoration. This is important. And strengthening environmental lawsuit model, for example, government lawsuit, a group representation, NGO, organizational lawsuit, and citizen lawsuit, because in the competence of the court now is different because a new acts, and strengthening the way to handle corporate crime or corporate liability, because this is also important because the big corporate where in many cases of forest fire, and the monitoring and evaluation system. This is important for the training, because related to the where the alumni of the training need to still handle and improving their knowledge and skills. And we share of case where as a landmark decision to the alumni of the training to make their improving their knowledge and continue to commitment to increase the capacity of environmental judges in Indonesia by collaborating with external partner. For example, with Norwegian embassy, with some NGO to improving the quality and quantity of the environmental judges in Indonesia. Next. Okay, thank you.
Thank you very much, Judge Bambang. And I know Justice Pepper was thinking about the idea of having 1,262 judges at first instance. The challenges, I think, of Indonesia with a population of 250 million compared to Australia or New South Wales with a population of, I think, about 6 or 7 million is also very interesting. And so I now thought if we could turn to Thailand and, you know, Justice Angkana, the environmental divisions of the Thai court, both the Supreme Court and the Supreme Administrative Court, have been in operation for a number of years. There is currently discussion about a new rule of procedure in environmental cases. And I know that there was some discussion about the establishment of an environmental court, a complete Thailand environmental court. And also Thailand has had a number of very important judicial decisions. I think Judge Bambang has mentioned a couple of Indonesian decisions that were actually, we were considering in some of our earlier sessions, including the anti-SLAPP suit provisions in Indonesia and also the Jakarta air pollution case. But Thailand has also had a very important judicial decisions. I think about one of the cases on global warming, which now is, I think, 7 years old, but we've also had the Black Panther case on the question of holding people liable, including important people liable for environmental harm. And also environmental pollution, such as the Clitty Creek case. I'm wondering if you could share with us some thoughts about the work of the Environmental Case Division of the Supreme Court of Thailand in environmental adjudication cases and the work that's happening now.
Okay, thank you, Matthew. And good afternoon, honorable justices and all participants. And thank you for inviting me in such an incredible conference. Actually, in Thailand, right now, we don't have environmental court. We only have the Green Bench, one division in the Supreme Court, the highest court of Thailand, and the environmental division in the Court of Appeal, Region 1 to Region 9, and the Central Appellate Court. So about Thailand court system is a dual court system composed of the Court of Justice and the Administrative Court. And environmental dispute may be brought in either the Court of Justice and the Administrative Court based on the issue involved. The jurisdiction of the Green Bench of the Supreme Court covers civil and criminal cases that may arise from various national resources and pollution law. But the majority cases is a criminal case, and the Black Panther is one of these criminal cases. Currently, the division has no special rule of procedure. I think many of you know that the characteristic of the Thai legal system in civil law jurisdiction, judges are limited to the interpretation of the Constitution. And the law and court decision must be within the existing legal framework. So the environmental cases are filed under existing civil and criminal procedural and substantive laws, which present challenge to environmental plaintiff, like strict standing rules and a standard of proving causation. So in my opinion, the development of environmental jurisprudence has been slow in Thailand. However, the Green Bench of the Supreme Court, which had the research division, play a very important role as the center for assisting the lower court to search legal matters in environmental issues. Even though the Green Bench has limitation of the legal framework and does not have the environment procedure, there have been jurisprudential breakthroughs in many cases. One of them that I should explain here to the case in 2009, a water pollution case. The Environmental Division of the Supreme Court relaxed the plaintiff standard of proof by using the approach of approximate cause. That causation does not need a perfect scientific certainty how the damage occur and high probability insufficient for causation. Then the court had shifted the burden of proof to a defendant, the motorcycle spare part manufacturer, contrary to the civil procedure. So another case is in 2014, the spirit of the law related to natural resources under the national park is to preserve and conserve the ecological system of the park by not allowing any person to live or not allowing buildings to situate in the area as an alien to it. The division point out that removing the buildings in the underlying goal of the law for managing of the national park in a sustainable way, even though the removing building order was not requested by the prosecutor or the plaintiff. This is also contrary to the rule of procedure as well. So those rules set a new precedent decision in the issue of law by expanding the rule of procedure. About the click case that Matthew mentioned, the division also play an important role to give the rule for the calculating about the damages for the natural resources, which very has the argument in our division, which one is the proper method to calculate the compensation to the plaintiff. So right now, Thailand does not have specialized rules of the procedure for environmental issues. The Court of Justice and my division, the Environmental Division of the Supreme Court, put so very hard to have the environmental procedure. The draft is right now in the process of developing procedural rules for the environment to address stranding, evidence, and alternative dispute resolution or ADR. The draft allows for the use of expert witnesses and out of court judicial investigation and also relaxed procedural rules that I mentioned in 2 cases before. Not only the draft of new rule of the procedure, but the division also give an important rule to prepare for the guidelines for hearing and hearing environmental cases, both in civil and criminal cases for the lower courts. The judgment of the division is an important instrument in developing jurisprudence on enforcement and implementation, which provide guidance to the lower court in environmental sentencing. So in my opinion, I think the division take the lead in enforcing the law and attempt very hard to fill in the legislative gaps in order to support the right in a healthy environment, the fundamental right and restoration for natural resources. And if we're lucky next time, all of us, including me, that we have met in another conference, Thailand might already have the specialized environmental procedure to enforce. Thank you, Matthew. Back to you.
Thank you very much for that, and certainly, I hope that environmental procedure will be able to enter into force. I mean, you touched on quite a number of issues of standing evidence, expert witnesses, and alternative dispute resolution. So I was just going to go back to Justice Pepper. The Land and Environment Court, and I say this as a former practitioner, has quite detailed rules of procedure. It has guidelines for expert witnesses, quite strong and still innovative guidelines on getting witnesses together. In terms of those issues about rules of procedure and even case management, how important do you think they have been to helping resolve environmental disputes, and what lessons really can we learn about environmental procedures or rules of procedures in specialized jurisdictions?
Thank you, Matthew. Well, again, and I think this goes back to our status as a superior court, because we have all of the powers and rules and procedures that would be available to a superior court, in particular the Supreme Court. We use a lot of their practice and procedure rules. In fact, we have in New South Wales, we have the Uniform Civil Procedure Rules, which and the Uniform Civil Procedure Act, which really does confer great powers on the court. But of course, as you said, we're a specialist court, so we have developed some of our own unique practice and procedure in order to efficiently manage our lists, both civil and criminal, and to basically get through the volume of work, as every judge needs to, with the caseload that we have. But you've touched on I just want to mention a few things. One is we do use alternate dispute resolution a lot. So most of our cases, in fact, almost all of our cases that come before commissioners are conciliated. So it's a compulsory ADR, and that resolves a lot of the cases straight away before the need for a hearing. And indeed, even the judges refer a lot of matters off if they're suitable to mediation. Last time I looked at the figures, about 40% of those cases end up being settled without the need for a hearing, which is obviously preferable. Now, they don't apply in criminal cases, of course. We also have very broad rules of standing, not as rules of procedure, but basically as a result of the legislation that we have exclusive jurisdiction over. But you mentioned on one in particular that I did want to, perhaps brag about, and that was the what's called, we euphemistically called hot tubbing of our experts, or concurrent evidence, where we get the experts together. They confer without the presence of lawyers. And of course, because we're a specialist land environment court, we use a lot of experts. It's very expert heavy court in that respect, which makes it, of course, very interesting to sit on the cases. But we get the experts together without lawyers present, and they work through the issues themselves, and they produce a joint report. And then the joint report goes before the court. And of course, during that conclave, as it's called, or the hot tub experience, a lot of those issues get resolved, or they get narrowed and focused. And you find that the experts, particularly when they're with their peers, will agree on some matters, or at least try and narrow down the issues that are in dispute. And then when the experts come to present before the court, of course, they then sit together in the witness box, and they're cross-examined by both sets of counsel, again with a view to narrowing down the issues in dispute, which we have found produces a much more efficient method of getting the expert evidence out, instead of waiting for one case to finish and then the other case to start, which could be days apart. Now, as a judge, I can see both experts sitting together side by side. Often ideas will be bounced off each other, which is very helpful. There'll be further concessions that are made, and the judge gets a real sense of where the real, as I said, issues in dispute are. So we now, all of our expert evidence is dealt with concurrently in this fashion. We've been doing this for a long time in our court, and it's been highly successful.
And so, in terms of those experts, are they court-appointed experts, or are they the experts engaged by the parties in the dispute, recognising that Australia and New South Wales has an adversarial system where there are parties that are engaged? But are these the court-appointed experts, or are they parties experts?
No, we did try to encourage parties to consent to the court appointing experts. But we didn't get much appetite for that. I think because we are in an adversarial system, they just couldn't. They couldn't. No one could ever agree. So they're not court-appointed experts. They tend to be the parties' individual experts. But again, notwithstanding that, we do get a high degree, as I said, of narrowing of the issues in dispute, and a huge saving in time. And the presentation of the evidence is in a much better form to the court, which is fantastic.
And as you say, it seeks to focus the areas of dispute, and presumably the areas where there's no dispute, you don't waste time or effort looking at those.
That's absolutely right. That's absolutely right. And because you're dealing, if you're an expert, you're dealing with your peer, and you're having a discussion at that expert level. As I said, I think you end up with a much more. You end up with a proper dialogue between the experts. And as I said, you also so what goes before the court is only the matters where there is real disagreement.
And I'm not sure, you mentioned about resolving quite a few disputes through mediation. Do you have any, and I know that I haven't asked you about this before, but about figures about how quickly many disputes are resolved in the Land and Environment Court?
I don't have those figures off the top of my head, I apologize. But it is a significant percentage. We would simply not be able to get through the caseload, the number of matters that are filed in our court each year without the compulsory conciliation process that occurs in the merits cases. And indeed, I think where appropriate, the matters that are referred off to mediation. And of course, again, and this goes back to your earlier question, Matthew, about one of the real strengths of this court is that we have these commissioners in the court as well. All of our commissioners are trained mediators. They're fully accredited. And so we can offer mediation occurring before commissioner of the court, which of course is free to the parties to that extent. And we try and match the appropriate commissioner with the appropriate matter that needs to be mediated. So if it's a matter that involves where there's a significant engineering question, we'll try and get a commissioner to mediate that matter who's an engineer. Or if it's an architectural matter, an architect. The tree disputes are conciliated by people who have arboreal qualifications, which is a huge help.
So I just have one question, if I can ask you, that's arisen. In terms of communities that might be bringing cases before the court for judicial review or participating, and they haven't got the resources to hire an expert, are there provisions in the court that enables or allows those people to still access that expert evidence, or can they approach the court for an appointment of an expert?
Not really, again, and I think this is perhaps one of the limitations of an adversarial system. Of course, in judicial review proceedings, there usually isn't expert evidence. So you're looking at you're reviewing or challenging the decision, the executive decision, which usually is done on the papers. There are rules and procedures about making sure that you get the materials of the decision maker so you can review the decision properly. To make sure that it's a lawful decision or unlawful as the case may be. And of course, you can actually ask for reasons of the decision maker. So that probably takes care of the judicial review cases, but otherwise, no, there isn't. There has been some talk by some organizations to build a body of, I guess, volunteer experts who will provide their services and times to community groups. And I have to say that's often what occurs is an expert will agree to act for, or rather be engaged by a community group, a community organization that doesn't have funds, and they'll do that on a pro bono basis. And I've seen a number of cases come before me where the expert has volunteered their time.
Thank you very much, Justice Pepper. Justice Azcuna, can I then turn to you just in terms of the rules of procedure, and we touched on the Supreme Court of the Philippines rules of environmental procedure.
Yes.
Within there, you mentioned the writ of kalakasan. Within there are also some interesting provisions for things for relief, such as temporary environmental protection orders, the issue of there's also provisions that deal with SLAP suits, strategic litigation against public participation. I'm wondering, from your experience and also in your other capacities as a trainer involved in the teaching of the judicial judges, how important is it for those rules of procedure to have things like temporary protection orders or the writ of kalakasan, or indeed, those provisions against SLAP suits, so that the court can dispose of those effectively?
The special rules that provide for these SLAP suits or writ of kalikasan or even the temporary restraining orders are very effective, but we need to inform the citizens about them. And so the Philippine Judicial Academy came out with a citizens handbook that contained in a simplified and layman's language all these remedies and how to access the different sources of these remedies from the viewpoint of a citizen. So that helped very much. I think this is very important to have a citizens' participation and to have the access to the remedies by the citizens enabled through some kind of facility. So I would say that it's not enough to have these remedies available. We have to inform the citizens about them and provide access to the remedies by them. And
so Justice, how, I mean, because we have one of the questions within the chat box about the challenges in the Philippines in an archipelago, in a large area. I mean, it's very similar to Indonesia. How can we get those cases before the court, and not just the Supreme Court? I guess it's also before the local courts that might have to deal with some of these matters as well. And in particular, in the question, can the plaintiffs be protected? Is that the role of the court, or is that sort of the role of the government to also protect plaintiffs, or even other lawyers, I guess, to protect plaintiffs who want to bring cases before the courts?
The way to provide for that effectively is to make the access to the courts free, or without having to pay fees. And generally, in a writ of protection under the Constitution, this free access is provided. So this makes it easy for them to access the remedies. Otherwise, there will be a financial bar because the fees, court fees, are quite heavy now. They have been increased to provide more finances to the courts, because we only get less than 1% of the national budget for the entire judiciary in the Philippines. We have a budgetary problem. So we had to increase filing fees and, however, provide free access to the courts for protection of fundamental rights.
And Judge, in terms of that aspect of providing access to the courts, do you think it's also been important that these are seen as fundamental rights? And I think you've mentioned the writ of amparo. Maybe you could explain a little bit what that writ is, that prerogative writ is.
Yes, the writ of amparo is a special writ to protect the right to life and liberty, and it is provided by special rules as well. This is aimed against extrajudicial killings or threats thereof, or even kidnappings by state agents or enforced disappearances. And so the writ of amparo, which is from the word amparar, to protect, is copied from Latin American countries and incorporated into the Philippines through the mechanics of the rule-making power of the Supreme Court. So this was extended to another form in the writ of kalikasan, which is also a writ of amparo really, but to protect another fundamental right, which is the right to a balanced and clean environment, which is a constitutional right under the Declaration of Principles of the Philippine Constitution. So these are all procedural guarantees from the Constitution itself. This is very important, that it is a constitutional remedy to a fundamental right.
Thank you very much, Justice Azcuna. And I think that idea of fundamental remedies, if I can move to Judge Bambang, because in terms of the Indonesian constitution, but also Indonesian law, I'm thinking about the environmental protection law, that has a specific provision that every person who is seeking to defend their right to a clean and safe environment shall not be charged with a civil or criminal offence. That's the English translation. And you mentioned that the courts are now broadening standing. Do you see that that will have an important impact on the cases that are being brought at lower levels as well as the superior courts in Indonesia?
Yeah, because this is the Article 66, but in the procedural rules we don't have. So the Supreme Court make a circular letter where this circular letter is a amount of guideline for the judges, where they handling the case related to the anti-SLAPP. Right now, we revise of this circular letter became Supreme Court regulation, but until now is still as draft. So I think in the middle of this year we will launch of this regulation, because if the judges only use of the circular letter from the Supreme Court, it's not legally binding to the parties. This is because many cases of SLAPP in first instance and in district court in Indonesia.
So, and I guess this gets back to the comment that Justice Pepper and Justice Azcuna has made in terms of the Supreme Court or the Land and Environment Court having essentially a power, I guess, to control its rules of procedure or to issue the rules of procedure. Is this something that exists in Indonesia, that the Supreme Court can develop its own rules, or does that have to also go to government for approval?
Yeah. Besides Supreme Court make a circular letter, also actually also circular letter about numbering of a case, where every case of related to the environment, the number of the case have the code, a special codes. LH means lingkungan hidup, means environment. So the every case related to the SLAPP, usually the prosecutor not use of the a crime, environmental crime, but use of a general crime. So the number is not use the special code. So sometimes it's difficult to monitoring of case related to the SLAPP. But the working group in Supreme Court have a large of network, so still monitoring of the cases.
And so, I mean, I was going to also ask Justice Angkana also about SLAPP, because that's a big issue also in the Philippines, in Thailand, and the government has also identified that in their interim report on business and human rights to try and address that, and there have been works done with prosecutors as well to help prevent those SLAPPs. But just focusing on something as simple as case numbering, that seems to be something that is also very important in terms of case management. And I think Justice Pepper has identified that the Land and Environment Court has adopted a fairly, and I say this as a practitioner, a fairly strong, firm hand on case management to ensure that cases are brought together and brought to the court. Is this case numbering the beginning of case management, do you think, in Indonesia for environmental cases?
Yeah. Besides the special number, so because in every court we must applying of case track system, where every case with a different different case with different number. So this is the way that we can monitoring the case, and then Supreme Court, if this case until to the cassation, Supreme Court can give this case to the special justice where have as you know, there's the what is that in English, the room, sorry, this is for controlling of the cases where, because the numbering for make easier to monitoring and handling the special case.
Thank you. So Justice Angkana, can I then also move to you and discuss you know, some of these issues about procedures, the anti-SLAPP suits in particular, and also, I mean, you mentioned one challenge in Thai courts were the calculation of environmental harm and damages, and perhaps you could talk a little bit more about those sort of two issues and how you think the judiciary is responding.
Thank you, Matthew. About the SLAPP law, I think there are a few cases in Thailand, and those cases only in the lower court do not bring to the environmental division of the Supreme Court yet. And for the calculation about the damages, in the general meeting of the division, every civil environmental cases, we also discuss about what is the appropriate compensation to relieve the victims, and also at the same time also restore the natural resources. That's why many times the division also had a project like a working group to learn about knowledge and the experiences from the economists to show us the way or the method to calculate the value of the nature, and maybe including the Black Panther case. The prosecutor, the Black Panther case is the civil case connecting to the an offense. So the public prosecutor also asked for the compensation about the life of the Black Panther to only 3 million baht. But the national parks go to the case and join to the plaintiff and ask for more to 12 million baht, equivalent to 400,000 US dollar. The lower court only award the compensation to 2 million baht. But under the existing legal framework in Thailand, if the plaintiff or the national park would like to have more compensation, the plaintiff and the prosecutor should appeal the compensation as the point to the Supreme Court to overturn the judgment of the Court of Appeal. But in this case, the public prosecutor and the national park did not appeal in this case. Only the defendant or the offender appeal the case. So even only in my opinion, I think a value of the living thing, just a wonderful creature, just like Black Panther, should have the value more than 12 million baht that the national parks ask for the compensation. Sometimes it's priceless for the national resources and the living thing in the whole environment. So it's quite a big and huge issue that actually, as I mentioned, the Supreme Court also have a research division, and many judges in the research division, just like me, try harder to figure it out. which one is the appropriate way to give some calculation for the compensation, learn from other countries, just like New South Wales from the Justice President, and also learn from the Philippines as well, and also from the Pakistan and India. But it's quite hard for the justices in the division to accept those international principles, because we only commit to the existing legal framework. So that's why I think we really need the special rule for environmental procedure, which will relax this strong commitment to our legal framework. Thank you.
Thank you, Judge Angkana. And perhaps I think that role of the research division is quite, I don't think it's applies in all jurisdictions outside of Thailand. Perhaps you could just explain a little bit about what you do as a judge of the research division in terms of a case that's when a case has come before the courts.
Okay, the duty for the judges in the research division, actually, the judges also draft a judgment and also give some advice, do the research, conduct the research in the point that the parties appeal from the appellate court. At the same time, in a case that justice in the Supreme Court only finished the draft of the judgment, the judge in the research division must review about the legal matter and the factual matter in the case. Is it okay? Is it under the legal framework in the existing framework, also under the Constitution? And sometimes we push very hard to apply the international environmental principle, just like polluter pay principle and precautionary principle. And in some cases that yes, the justices accept this principle, just like in the Critic Creek case that we use the polluter pays principle in this case.
Thank you very much. So, I mean, Justice Pepper, you mentioned that the Land and Environment Court, it does civil work as well as the criminal procedures. Just in terms of setting decisions on damages or fines and penalties and perhaps even restoration orders, how does the court go about that? Does it have guidelines, its own guidelines on punishments and fines? As some jurisdictions in Southeast Asia, for example, the Supreme Court of Sabah and Sarawak has developed a guidance on sentencing, as does the US Federal Court, I think, have a guideline on sentencing environmental crimes. How does the Land and Environment Court deal with issues of both fines, perhaps, but also compensation or restoration issues for environmental offences?
Well, these tend to be governed by the legislation that we have jurisdiction over, and the legislation sets out some of the principles and the factors that we have to have regard to, and we also look to the common laws. There's some established principles, particularly in relation to sentencing, that we must apply. And of course, we have a body now of jurisprudence, and this, I guess, again goes back to what I said before about sort of the benefits of having a specialist superior environmental court. We now have this expansive body of jurisprudence. So we have developed, I guess, in a sense, our own internal guidelines for sentencing, which will, once we've looked at the factors we have to have regard to, will guide us in coming to the imposition of a particular or an appropriate penalty. But a lot of the legislation that we deal with, particularly the legislation that deals with the creation of offences, also has conferred upon us some fairly broad powers in relation to restoration orders. So again, we have a broad range of powers under some of the legislation that allows us to not just impose fines, but also to direct that a defendant, for example, carry out a specific project or pay money instead of a fine, which would just go into consolidated revenue to the government, will pay that money towards a particular environmental project. And that I think that's hugely powerful. As we know, environmental crime, it can be so-called victimless. We all suffer for it, obviously, but it's much, I think, much more powerful to get the defendants to, or the offenders to actually restore the environment than just simply pay money to the government.
And in terms of those sort of orders and restoration orders, how are they? I mean, how are they enforced? Are they enforced? Because this obviously comes back to an interesting question about just the enforcement of judgments, which is really a live issue in some respects in many jurisdictions. So how are those orders for compensation, restorations or fines enforced by the court?
Well, with the two answers, I guess. One, just turning first to the criminal jurisdiction that we deal with. It is, I must say, assumed that when a court orders an offender to do certain things, to pay money or to restore the environment, carry out a particular environmental project, that will be done. And it's usually the regulatory body who has brought the prosecution that will then make sure that those orders are carried out. But in terms of the civil side of things, the civil enforcement, for example, jurisdiction that the court deals with, obviously breaching court orders is a serious thing. And if those orders are breached, then contempt proceedings can and often do result in the court. So the party has the facility to bring the matter back before the court, and the court can then exercise its contempt jurisdiction to make sure that those orders are enforced. And that usually does the trick. Again, it tends to be a fine, but on occasions people can be jailed.
Thank you very much. So I'd like to turn also to one of the questions that we have in the Q&A box from a very old friend and one of the great environmental lawyers from Sri Lanka, Lanath De Silva. I do want to acknowledge the amazing work that you've done over the lifetime of your commitment to environmental rule of law. And Lanath puts, it is evidence that South Asian judiciaries have made great advances in substantive and procedural jurisprudence. And I want to address this to Justice Angkana and then Judge Bambang and Azcuna and then Judge Bambang and then Judge Angkana. So Lanath says the South Asian judiciaries have, and judiciaries within this region have made great advances in substantive and procedural jurisprudence in the area of environmental law. From the writ of Kalakasan to the jurisdiction of the Indian courts, the Suwamoto jurisdiction that's been adopted and developed, and the development of public trust and guardianship doctrines, and I could add the stewardship doctrine that was developed in the resident mammals of the Tanyan Straits. In many ways, those developments, those jurisprudential developments, have outstripped developments in the developed countries. And the question is, do the honourable judges have thoughts on why this might be happening? Why some of these decisions in the courts within South Asia and Southeast Asia have moved beyond some of the decisions that we have in other countries such as Europe, the United States and Australia. Justice Azcuna, do you have any thoughts as to why some of these Philippine jurisprudence are really the groundbreaking, and they've been groundbreaking many years ago, so they really led the jurisprudence in the region?
Yes, I think it's our nature as Asians to be closer to our environment, since we don't have as much technology to separate us from nature. I think we grow up, being close to nature. We're close to rivers and trees and forests. So we're more conscious, I think, of the rights of nature in that way. That's why we are more advanced than other countries in developing jurisprudence to protect nature. It's really our relationship with nature. In fact, I think in New Zealand has already recognized nature as a party litigant. A river has been acknowledged as a person in New Zealand. The Philippines, the resident mammals of Tanyon Strait came close to being recognized as persons, but they still need a guardian, a natural person to file the case for them. But this closeness, I think, to nature, springing from religions of animism that preceded Christianity in our area, I think is responsible for this closer awareness to nature on the part of Asians, in my humble opinion.
Thank you very much. And Judge Bambang, in terms of how, how that is being developed within Indonesia, and some of the changes that you've seen in terms of people bringing cases towards the court.
Yeah. Supreme Court encouraged to the judges to applying of judicial activism, although that Indonesia is a civil law system where jurisprudence is not legally binding to the judges, but for applying the judicial activism, we have a guideline how to applying of judicial activism. We learn in many cases from another country, for example, for Australia, from Philippines, and also another country. And also we applying if in Indonesia there are no procedure, judge can adapt of the rules from the another country. For example, the procedure of citizen lawsuit, we don't have the procedural rules, but judges can applying of same with in the common law, judgment law. So in Indonesia, we are applying judicial activism.
Judge Angkana, would you like to?
Thank you, Matthew. I think in Thailand, there is different because the traditional way of life of the people who live in the forest or in the village near the national creek, that the government should pay attention and give an opportunity to them first to ask them to move to another place that government can prepare for the habitat to the people. And also in the Thai law that we also, even we lack of the special environmental rule, but in the draft of environmental procedure that I mentioned, the draft also thinking about the poor people. That's why one of the barrier of access to justice is about the cost, the high cost for the court fee. So the draft try to give some exemption for the victims, and also in the case of public interest, we give expand standing to community representative and NGO to file civil and enforcement environmental case that we also accept for the court fee for this kind of the standing as well. And I think also if we give the knowledge to the people, and people can understand which one is the legal and which one is the illegal action. If there, can I explain about the public land encroachment right now? Many people who are the offender in the criminal cases, most of them are the poor people, and the division also find the alternative sentencing and also alternative penalty for the offender, just like suspending the sentence maybe for 2 years, or only impose the fine penalty to relieve the offender and try to changing behavior. Because sometimes if the court impose the imprisonment, this not can change behavior. And also sometimes we also, in our the new rule in the environment procedure, we also give alternative penalty, just like a community service as well. That's why the poor people who cannot find earn the money to pay the fine penalty, they can go to another way, to alternative way.
Thank you very much, Judge Angkana. And we are also joined, and I'd like to welcome Justice Antonio Benjamin. Justice Antonio Benjamin is on the National High Court of Brazil and has been there since 2006. And in his capacity also as lead founder of the Global Judicial Institute on the Environment, has been a great supporter of the work both of the ADB and UNEP for judicial training around the world. So Justice Benjamin, welcome indeed. And perhaps this is one of the things I would like to sort of, as we are moving towards the closing session, is one of the questions that has come up perhaps as the theme of this entire 3 days and was asked in the question in the chat, is about environmental justice. And perhaps I could ask all of the panelists, all of the distinguished judges, to comment on this idea of, are the courts there for environmental justice? And if so, how can the courts promote and enhance environmental justice? We've discussed issues from climate change, issues of SLAPP suits. We've also talked about the role of the courts in dealing with poor plaintiffs and forest-dwelling plaintiffs who may be in breach of the law, but nevertheless are very connected to the environment and the challenges there. So perhaps if I can ask each of the honourable judges in turn about their views of the role of environment courts in this concept of environmental justice, and what that means in the context of where we face these triple planetary crises that we talk about, of climate change, of pollution, and biodiversity loss. So perhaps Justice Pepper, can I put you in the hot seat and ask you first to address that issue?
It's a really good question. Thank you, Matthew. Really, and the last question was absolutely fantastic as well, and I'm sort of reflecting on it. In Australia, we don't have a tradition of, for example, judicial activism. In fact, it's frowned upon. So how do we get this concept of environmental justice out there? And we can obviously do it through participation in conferences and forums like this. We can get this, we can get the message out through education, obviously. But for me, the key is really access to justice. We need to have access to courts. We need to, you know, and those are all the sorts of things like open or broad standing, making sure that you don't discourage people from bringing suits by having prohibitive costs regime, which is one of the things that I didn't touch upon, but we have rules for that in our court. It's, you know, in Australia, we are confined by our constitutional structure about how we can and can't operate as courts and as justice, as judges in those courts. And of course, we don't really have a tradition of protective human rights legislation either. We only have 3 jurisdictions that have human rights acts. New South Wales is not one of those. We don't even have a federal human rights act. We have nothing in the Constitution that mentions any human right whatsoever. And there's certainly nothing like, you know, the right to a healthy environment or anything that we find in other, I think, much more progressive constitutions in the Southeast Asian jurisdiction. So for us, for me, at least sitting here as an Australian, it's about, I think, making sure that people have access to the courts, making sure that people are aware of the courts, making sure that we have strong environmental laws as well. That's very important. Now, that's probably more of a political issue to make sure that our parliaments pass strong laws so that people have rights to enforce, and that once they have those rights, they have a place to go to vindicate or get those rights enforced, which is, as I said, having strong judicial institutions with robust rules of procedure, open access, and making sure that people aren't discouraged from bringing suits by having, anti-suit injunctions, prohibitive cost rules, and so on.
And Justice Azcuna, in terms of, from your background and perspective, environmental justice is clearly something that you focus on.
To me, our concept of the environmental justice is to give every person his or her due. And above all, we now recognize, or almost recognize, nature as a person. The Constitution provides that we have to respect the rhythm and harmony of nature. And so, first of all these laws and rules should aim at respecting the fundamental right of nature to its rhythm and harmony. And human action have many ways destroyed nature, and we have to restore the destruction. The coral reefs, for instance, are very heavily damaged. There was an incident where I think U.S. Navy vessel, submarine, hit the coral reefs of the Philippines, and they had to pay for the damage. This is environmental justice. But sometimes it is the poor who violate these rules. For instance, poor people in the foothills of the mountains gather firewood from the forest, and this is technically a violation of the rules on the environment, and they get prosecuted. But they are poor people, and they need the firewood for their livelihood. So the courts have to have some discretion in finding people guilty of violating the environment. So there has to be a balancing. This is the kind of environmental justice that we should develop, with a sensitivity to really apply the sanctions where they belong, and to be able to distinguish between the real culprits and the nominal violators. This is something that still needs to be developed, but the idea is justice is to give every person his or her due, including nature. Thank you, Matthew.
Thank you. And Judge Angkana, I know you have always spoken on environmental justice.
Let me talk about in my opinion for only Thai aspect. I think how to access to environmental justice. First, I think the judiciary, also the judges, are challenged by understanding scientific and expert evidence, and also evaluating such complicated evidence, and understanding how to evaluate environmental damages that I mentioned in different circumstances. So the key challenge that faced by most jurisdictions in Thailand regarding environmental remedies is the lack of the legal tools to address environmental harm, and most rely on the civil damages remedy, which are not appropriate in most environmental damage cases. And let me talk about the environmental court. As we know that Thailand still does not have environmental court, but maybe in the near future we might have one. In my opinion, the environmental court are an important tool as well, but but the environmental court does not the only tool to resolve environmental challenges, but a well-established rule of law, strong rule of law, as Justice Pepper mentioned, and well-developed experience for the judges, building about the capacity and for the not only the justices and also the prosecutor and in the enforcement agency with expertise to give some kind of education for them and building capacity for the those staff in the legal system that we can move forward for the access to environmental justice.
Thank you. And Judge Bambang, in terms of environmental justice in Indonesia, how do you see?
I think environmental justice is not related to the human rights, but also human rights as a part of nature. So my respect to the Justice Antonio Benjamin, where have idea about in dubio pro natura. This principle always we sounding to the judges in Indonesia. So I think environmental justice is not only for respect to the different race, color, national, or income. And several cases in Indonesia where the parties is person where consent to the environment that they have activity to protect the environment, but the big corporate have this is about slab. So for example, this case about between Walhi and Freeport, and also the case Robandi case where I in the presentation. There's also the example for the cases where Indonesia is applying environmental justice is not protect to the human, but the reason as a protect to the nature.
Thank you very much. And so, Justice Benjamin, again, welcome. And on this question of environmental justice, you know, this is something I think that has motivated you throughout your career, and especially the environmental rule of law. Perhaps you could just give us an observation on how you see the role of the courts in developing environmental justice. And may I just ask the indulgence of the panel, because after Justice Benjamin has given his answer, I would like to ask you all one final question about the value of judicial training and judicial education. But again, Justice Benjamin, please, providing some thoughts on that journey on environmental jurisprudence and environmental justice.
Well, many thanks, Matthew. I was expecting to speak only at the closing and just be watching our dear colleagues speaking so beautifully on those issues. It's very early here, but the two questions posed are in fact interconnected: environmental justice and the debate about judicial activism. I think, first of all, on judicial activism, we should keep in mind that, fortunately, at this stage, protecting the environment is not a decision of individual judges. This is mandatory in constitutional provisions, and not the case in Australia, as Justice Pepper mentioned a minute ago, but in most countries. And it's there is a huge amount of legislation, as mentioned by Justice Angkana. So the judicial activism is, the activism is not with us, the judges. The activism pro-environment is in the Constitution and in legislation. Very different from 1972. We'll be celebrating soon the 50th anniversary of the Stockholm Declaration and the Stockholm Conference. So very important that we tell the students and everybody in our countries that we protect the environment, we judges, not because we want, but because it's our responsibility put upon us as a duty in the Constitution and in legislation. On the second issue, the environmental justice, this term is fuzzy because in the United States, it has a different meaning. In the United States, environmental justice is a subject that brings attention and focus to people, the most disadvantaged and vulnerable, poor minorities that are affected by the detriments of pollution and environmental degradation. But I think for everybody else in other parts of the world, environmental justice is the point of departure and the end product of the environmental rule of law. So what we do is to, through our work as judges, but in applying the constitutional provisions we have and the legislation, is to give our constituency environmental justice for all, with special attention to minority groups and those that have no access to justice whatsoever. Thank you.
Thank you, Justice Benjamin. And I've been a dreadful timekeeper because we've run out of time. Can I certainly just invite then, instead of, I think we'll take it as read that environmental education and environmental capacity development and training for judges is as important as it is for environmental lawyers and environmental academics. Can I then invite very briefly a final observation or a final comment about your role or your perception on the role of environmental courts in environmental jurisprudence? And perhaps I can go to you first, Justice Azcuna, for just as a closing remark.
Yes, thank you, Matthew. I cannot overemphasize the role of judicial academies in training of judges in environmental cases. The judges need training like everybody else, and training brings them up to the fast developing jurisprudence really in the field of environmental law. And as they say, the key to excellence is training. So judges have to be trained on a continuous basis. In the Philippines, training is done by the Supreme Court through an academy called Philippine Judicial Academy, which I headed for 12 years. I'm now retired recently, and there's a new head, also a retired justice, Rosemary Carandang, a lady, and this is a very critical role for her, and I wish her all the success. We have 3,000 judges to train. All our courts are environmental courts, by the way. The Supreme Court has declared all courts to be green courts. So we have to train all the judges on environment. Thank you.
Thank you. Judge Angkana, would you like some kind of closure?
Thank you, Matthew. Just briefly, the training for the judges to making the capacity building, I think is very important for the Thai judiciary. The Judicial Training Institute always put a course for the judge trainee to, as it's like a mandatory course to learn about environmental law. And so the ultimate first step in training green judges, I think, is the development and cultivation of their environmental awareness. Without this, judges, even you are just junior judge, would not be able to appreciate environmental issues, and don't think the environmental problem is a key important role in our life. So when faced with the contending value, social justice and ecological justice, the judge might learn and know the way to develop their skill and their experiences to learn from the maybe from the other countries also, and also from the principle, international principle, to understand and give the value, the proper value for the environment. Moreover, if it will can be, I think, if we could have a good chance, we might join as a regional network of the judicial institution for making capacity building, that judges can learn the best practice experiences from other countries in the region. So yeah, just like me today, I learned from the New South Wales, from the Judge Bambang, from the Judge Pepper, Justice Azcuna, and also Justice from the Brazil as well, and from you too, Matthew. Thank you.
Thank you, Judge Bambang. Some closing words.
Yeah, thank you. As a judge, was right now also as a dean of the Judicial Training Center, I think study is a long life study. So I think never give up for to improving training and education for judges. Although there are many challenges, including pandemic COVID. So training for the judges, especially in as environmental judges, can deliver in many ways, many methods, and also not only improving knowledge, but we must, in the term of Indonesia, improving mentality, integrity for judges, support them by a good guidelines and a deep awareness of ecological justice. And then I think we must improving our collaboration among ASEAN judges, Asia Pacific judges, and also global judges. Thank you.
Thank you, terima kasih, and also thank you, Judge Bambang, for being with us at the end of the day of I think the sixth or seventh day of Ramadan. So thank you again, which also, I guess, acknowledges the importance of the cross-cultural issues we have in Southeast Asia, from the Hindu to Buddhist to Christian to Muslim. It shows also that cultural thing. Justice Pepper, if I can give you the final word before we go into the closing session, and thank you all for your participation. But Justice Pepper.
I love Justice Azcuna's comment that all courts are environmental courts in the Philippines. And I think that's what really we need to strive towards. It's not the case in Australia. And I think that's a problem, because you're now, environmental problems are global, universal problems. And my worry is, particularly in a country like Australia, is that you're now seeing a lot of litigation occurring in courts where you don't have that training, you don't have that knowledge, you don't have that scientific basis for some of the decisions that are being made. So again, I can only echo and endorse what everyone has said about the need for training, capacity building, and knowledge sharing, because, as I said, to emphasize, the environmental problems, particularly surrounding climate change, are universal, and we must all pool and share our knowledge.
So again, thank you all, honourable judges. I'm not going to attempt to sum up what has been a very fruitful and amazing panel. I thank you again for your service, for your time today, but also for your services as environmental judges. So thank you very much indeed. We are now going to move straight into the closing session of the second ASEAN Environmental Law Conference. So if I could call on Dr. Georgina Lloyd from the United Nations Environment Programme to make some final closing remarks. She'll be followed by Bryony Eels, and then Justice Benjamin, and then I'll make some final concluding thank you. But thank you all to our judicial panel for your presence here today.
Thank you very much, Matthew. So just confirming that you can hear me. I'm getting strange messages. Thank you so much, Matthew. I mean, this conference has really identified opportunities and good practices to advance environmental rule of law. It has showcased really the incredible work of the range of lawyers, activists, judges, and legal experts. And I want to do something in the closing to get some participation from the audience. I would really like to encourage everyone to write in the chat box one thing that you will take away from this conference. Maybe something that has inspired you, something that has resonated with you, as something that you have learned that you will bring into your work. So please do share in the chat box something that has inspired you, resonated with you, or that you have learned. I found the address by Justice Malik this morning to be really insightful on the innovative orders and judgments that have addressed environmental challenges in Pakistan. And many of the statements and inputs by the justices in this last session have really echoed those. The other thing, though, is while I have found the sessions hugely inspiring, the conference has also made it clear that we still have a way to go to put environmental law and justice principles into practice. There's more that needs to be done to uphold the rights of everyone to a clean, healthy, and sustainable environment, to protect environmental defenders who are critical partners for environmental law, to give that access to justice, and to build strong, transparent institutions to implement and enforce environmental law. We need to continue to be brave, to innovate, to be proactive in our work to advance environmental rule of law. And I think together we can support the planet and protect it for future and current generations. Particularly one quote that has come back to me stems from the discussions on day one that was raised by a public interest lawyer, that the law is the law, but practice is practice. And I think that really brings home the need to bridge the gap to ensure that we see in practice what is in alignment with the law, that there is full and effective implementation and enforcement, and that environmental justice principles are realized, and that prosecutors, lawyers, and judges are equipped with expertise to bring and adjudicate cases to protect our planet. I am optimistic. I think this is possible. And the conference has again demonstrated a large number of legal stakeholders dedicated to environmental law. So we just need to build this groundswell so that all judges, all courts are environmental courts, all lawyers are environmental lawyers, and everyone has the green lens and acts in the best interests of our planet. Thank you so much for joining the 9 sessions of the conference and the 3 special sessions. A huge thank you to all the speakers, to the interpreters, and of course to the core organizing team from the Asian Research Institute for Environmental Law, ADB, USAID, and my colleagues at UNEP. Special thank you and shout out to, of course, Matthew, Rocky, Paolo, Colleen, Pum, Angelo, Gladys, Bryony, Peter, and Sally. So thank you so much, Matthew. I wish you all a wonderful rest of your week, and back to you.
Thank you very much indeed, Georgie. And if I can now call on Bryony Eels from the Asian Development Bank to say a few words. Thank you very much. And after which I'll call on Justice Benjamin.
Thank you so much, Matthew. Hi, everyone. Good evening. Hello to our respected guests. I understand over the course of this conference that we've had people join us from 61 different countries, and we are so delighted to have a community of people around the world interested in environmental law and justice in Southeast Asia. Now, the day has been long, so let me start with some thank yous. I know Georgie has done them, but I would like to thank our partners for their support and cooperation with the second ASEAN International Environmental Law Conference. So thank you to the Asian Research Institute on Environmental Law, to the United Nations Environment Programme, USAID Reducing Demand for Wildlife, the Global Judicial Institute on the Environment, and the College of Law. I also understand that Matthew will thank some of our other conference supporters, many of whom with whom ADB frequently partners. Also, many people have worked so tirelessly to make this conference a success. Matthew Baird and the Asian Research Institute of Environmental Law. This event would not have been possible without you. You conceived the idea and you drove it forward, and your tireless efforts and have been to the benefit of everyone. Also, let me thank the conference team who brought this event together seamlessly. Angelo Jacinto, Gladys Sangalang, Amy Alcala, Colleen Salamat, Pum, Paolo, Rocky, Georgie, and Sally. Thank you, team. You not only pull off conferences seamlessly, but you actually make it fun to work with you. To the speakers, moderators, and those who participated in sessions, thank you for your insights and participation. Not one of us can know everything, and public speaking is really hard. So I hope the past 3 days have provided opportunities to share knowledge, network, and learn. As Damien Eastman, ADB's Deputy General Counsel, said this morning, today's discussion focused on judicial remedies in climate change and environmental law. The program was deliberately designed this way because humanity is in the decade of action. Earth and all of her people, species, and ecosystems need all arms of government to understand what's at stake and how they might play their part in achieving the global goals on climate change, sustainable development, and biodiversity conservation. We must remember that domestic legal policy and frameworks underpin global action on climate change and environmental and biodiversity protection. These frameworks are the backbone of local action. And if we ask what judges can do, our response is that they can minimize the impacts of climate change and environmental degradation by ensuring that everyone in the economy complies with their legal obligations. Quite simply, by upholding the rule of law, judges enable and support legislative and international commitments made by their central governments. But as global challenges become more complex, the judiciary is pushed to craft 21st century responses to 21st century problems. Traditional awards of monetary compensation may not be enough. And we've heard judges talking today about their ideas for other ways to ensure environmental justice is upheld. And ADB really is excited. We stand ready to assist the judiciaries of Asia and the Pacific. And we stand ready to work with our development partners, USAID and UNEP, especially in the launch of the Judicial Masterclass program to innovate in judicial education and networking. As well, ADB will be publishing a remedial orders handbook, because from everything we hear, sharing information and ideas about judicial remedies is critical to environmental justice. But I would like to finish with a quote, and it's a quote that I keep above my desk every single day to remind me to keep putting 1 foot forward in my practice of environmental law and climate change. It can often feel like you're in a cone of silence, or there's absolutely nothing new that you can add to the perspective that's already been added by geniuses and titans of environmental law who have worked and walked before you. On those days, I remind myself of the words of Henry Van Dyke, who wrote, "Use what talent you possess. The woods would be silent if no bird sang except those that sang best." So, my fellow environmental lawyers, keep singing, keep writing, keep talking and working. It will take a forest of us to make this decade of action count. Thank you so much. Over to you, Matthew.
Thank you, Bryony, very much. And so can I now introduce Justice Antonio Benjamin, driving force of environmental law jurisprudence, former chair of the World Commission on Environmental Law, and we had a great session on that yesterday, and the driving force behind the Global Judicial Institute for the Environment. Please, the screen is yours.
Many thanks, Matthew. On behalf of the Global Judicial Institute on Environment, as its president, I would like to congratulate the organizers for this extraordinary event. It's already the second, and I notice in the chat that participants are asking for dates for the third. So this shows how relevant and at the same time how successful this event has been. I'll make just 2 points here. One, as Georgina Lloyd mentioned, there is a gap between the law and the practice. And if we can translate this into a non-legal jargon, we can say, let's walk the talk. And that's precisely the main challenge that we face nowadays. We have legislated all over the world for the protection of the environment, from constitutional provisions to all sorts of laws, federal, states, municipal, and so on. But there's still this huge gap. And I repeat Georgina's words, between the law and the practice. There are many reasons to this gap. And this brings me to the second point that I would like to make. One of them is the lack or the insufficient knowledge about environmental law. We cannot ask people, even those that are on the ground and have new duties imposed on them, to comply with legislation that they don't know about. We cannot ask judges to decide very complex environmental issues if the judges are not aware of the basic legal framework and the science behind those legal provisions. This leads me to my final consideration. This type of event and others that are happening, particularly in Africa and Latin America, have as their main purpose to try to fill the gap of knowledge. This is a task that will never end, because the science of environmental law and the legislation is changing all the time. And we have new people, new judges that are recruited, public prosecutors, law professors, and so students, and so on. I think, in conclusion, that what's happening in Asia through the work of UNEP and the Asian Development Bank is a model for the world. I have said this many times. Georgina, you know how UNEP works around the world. You have the full picture. You know how much environmental law has advanced, for example, more recently in Africa, with the network on environmental law of judicial academies. But you also know that there is nothing similar to the work that you have done in Asia and the Pacific through this powerful combination of UNEP and ADB. My hope is that this model, and as a big fan, I'm always advocating this, my hope is that this model is replicated in other parts of the world. So congratulations, Matthew, to the whole team, to Georgina and the whole team at UNEP, to Brian O'Neill's and the whole team at ADB, and to all partners. Unfortunately, I cannot end with a poetic note as Brian Niels did a minute ago. But I think environmental law in itself, at its core, it's poetic because it has to do with the protection of the community of life. And there is nothing more poetic, not utopian, but poetic than protecting life. Many thanks and congratulations.
Thank you indeed, Justice Benjamin. And thank you for getting up very early for us for this closing session. I'm not going to repeat all the thanks that were made before, except in a little bit of, I'm going to break that rule. But I do also want to thank our translators over the last 2 days, Jerry and Samson, Akarin and Thirapat, the hidden voices for our Thai and Chinese translations. Thank you very much indeed for your support. I also, again, want to acknowledge the extraordinary work of the whole team, without whom this just technically wouldn't be possible, but also support from the Asian Development Bank, Christina Pack and Brian Eels, and the College of Law, who actually made the financial contribution that enables a conference like this to be put on. Even though it is a virtual conference, the Zoom event platform and all the other costs associated with putting it together don't come cheap. So thank you, Asian Development Bank and the College of Law for that, and the USAID for assistance with the translation. But above all, can I just say, focusing on the words of Justice Antonio Benjamin and acknowledging the extraordinary work that Georgina Lloyd does in her role, taking over from Andy Rain in the Bangkok office of UNEP. The commitment for environmental law there has been something that in my 35 years of environmental law experience, I haven't seen. It's just been extraordinary. Your commitment to the cause and to the work and to the work that we do, the conferences that we put on with ARIEL, and bringing together the global network of UNEP has been nothing short of extraordinary. And I also point out the work of ADB, Bryony, your work on climate change is world-class, and you demonstrated that today. Bringing together such an extraordinary group of speakers, moderators, and our 3 keynote speeches, each of whom I thought delivered brilliant overviews and synopses of some of the issues about Indigenous people, environmental crime, and hearing from the first justice at the Supreme Court of Pakistan was simply inspiring. But again, to all of those 1,400 people who registered for the conference, I hope you will be able to keep in touch. To the 600 people who agreed to be part of the Asia Pacific Network for Environmental Law, we will certainly be in touch. And that comes back to, I think, Justice Benjamin's prime comment. It's through collaboration we make the difference. Each of us do our own work. We sing individually, perhaps in the forest, but as a chorus, we have a voice that is unstoppable. Environmental law is not an easy profession. Defending the environment, defending human rights. We've heard of the great challenges that people like that face, that people face every day. But above all, we know that it is a struggle and a fight and a commitment that we are happy to make because it is our future. On behalf of the Asian Research Institute for Environmental Law and all our partners, the Environmental Defenders Office, Earth Rights International, the World Commission on Environmental Law, the National University of Singapore, Asia Pacific Centre for Environmental Law, LexisNexis, the Macquarie Centre for Environmental Law, Climate Justice, Climate Reality Program, the Indonesian Centre for Environmental Law, Law Asia, in Laudato Si, and the Climate Justice Coalition. I really want to thank you all for your attendance and participation today. And on that, I would like to draw this second ASEAN Environmental Law Conference to a close. Thank you very much. Sawadee Krap and good night.